Good afternoon, everyone. I am Greg Downey. I teach law courses here, and unfortunately, one of the topics that I don't cover as much as I would like to is the First Amendment. I think the First Amendment is extremely important. It's important to not just my students, not just all of you students, but to everybody. If you're a citizen of the United States, you should put it upon yourself to learn as much as you can about the First Amendment and all the amendments in the Constitution itself. So what I did, and was very fortunate to get agreement on, is I asked a renowned expert on the First Amendment to come speak with us today, Mr. Larry Walters. Larry's been practicing for over 30 years. He specializes in free speech, but he also teaches in other areas that are important to wholesalers, like internet law, intellectual property, even gaming and software law. He's the past president and national chairman of the First Amendment Lawyers Association. He tries in courts all over the country, but he's actually tried 3 cases in the U.S. Supreme Court. I'm going to pause and say that again. He's actually stood in front of the Supreme Court 3 times. That's like the equivalent of playing in 3 Super Bowls. He publishes many articles and has filed, his high-profile cases are filed in the national news, including CNN, Fox News, The Oprah Winfrey Show, Good Morning America, and The View. So, having said all that, this is, the man owns the URL firstamendment.com, so I think he knows what he's talking about. Please give a good, warm, full cell welcome to Mr. Walters.
Thank you, Greg, for that kind introduction. I hope I can live up to those words. Sometimes when I hear those introductions, I'm wondering, is he talking about somebody else? But I appreciate the opportunity to be here, and welcome to today's presentation entitled Speaking Freely, the First Amendment's Protection of Modern Media. And I appreciate Full Sail's hosting this event and welcoming me here, and all the people who have joined online and here in the audience. Thank you for your time. Hope to teach you a little bit about the First Amendment and how it protects various categories of speech, what the exceptions are, and how all these rules came to be. I've been fortunate enough to practice in an area of the law that many other lawyers only dream about. In handling free speech rights cases, I've been able to represent clients ranging from software developers to protesters to exotic dancers. But the one thing that they all have in common is that they need the protection of the First Amendment for some reason, and it's usually because somebody doesn't like what they're saying. Somebody wants to silence their speech or regulate it in some way. And it's always a pleasure to speak to students about First Amendment rights because they've become so much more important in our everyday lives these days. You're the ones who will carry on the tradition of freedom of expression and potentially get involved in some of these battles in your career. The First Amendment protects the kind of content that Full Sail teaches their students to produce. So it's critically important that you know what your rights are, what the government can and can't do, and what kind of speech is protected. But so before we get into the law and the rules and so forth, a few questions for you that I'll throw out. Is hate speech illegal? That's a question that a lot of people get wrong, and that's caused a lot of debate lately, particularly on college campuses and other locations where offensive speakers, alt-right speakers, white nationalist speakers have come on campus and stirred up a lot of trouble. So we're going to talk about whether hate speech is protected by the First Amendment and to what degree. How about this one? Can you possess obscene material in your home? Something that's been legally declared obscene and illegal by a judge or a jury. Can you read it? Can you watch it? Can you look at it in your home? The answer might surprise you. Is Facebook or Twitter responsible for their users' promotion of sex trafficking or terrorism? Are these platforms responsible for what their users post? Well, the answer is depends on whether it's sex trafficking or terrorism based on some things that have happened just in the last few days. Are bullfighting videos illegal? Sounds like an odd question, but that actually resulted in the passage of a federal law and a United States Supreme Court case that became very important to the development of First Amendment law. So we'll talk about that a little bit. How about computer code? is computer code itself protected by the First Amendment, ones and zeros and object code and source code? It's an interesting one, not fully settled by the courts, but there's some cases that we'll talk about, and the development of the law is fascinating in that area. Finally, can a 17-year-old girl who takes a nude selfie go to jail for producing child pornography? Or is that protected speech? Or is because she's underage, does she have some kind of protection for creating that content? I can tell you the answer to that one is yes, and in a lot of ways it's unfortunate, but there are some things that are being done to deal with the issue of teen sexting. So we'll address that. So hopefully you'll find some of this content interesting and walk away with more information about the First Amendment than you had coming in here. All right, so why are we doing this? Why are we talking about the First Amendment? Why is it important? First of all, we're all publishers now. And the issues that we're talking about today used to only affect a limited number of media companies that would write things and publish things, make movies and so forth. But now we're all doing it. Every time we post a comment, every time we write a blog, every time we write a review on Yelp or Amazon, we are publishing to a nationwide, even a worldwide audience. So we need to know about things like fair use and invasion of privacy and the kinds of things that only used to be important to large media companies. It's now affecting everybody. Fortunately, the courts have been fairly friendly to First Amendment rights over the years. And this is conservative judges and liberal judges alike, Republicans, Democrats. There's been some empathy towards First Amendment rights, and we have a fairly solid Supreme Court currently when it comes to protection of the First Amendment. So this kind of crosses party lines when it comes to freedom of speech, because everybody wants their own speech to remain protected. Now, in First Amendment cases, we start with the presumption that all speech is protected. So you don't have to show that the content you're creating here at Full Sail falls into some category of protected speech. Anything that somebody creates, any creative expression, movies, videos, music, etc., is presumed to be protected, and it's up to the government to try to strip that content of protection. And that's often a pretty heavy lift, as we'll see. Now, let's talk about student rights for a second. Do students have rights? Well, that was an open question for a while. But there was a case that arose in the 1960s during the Vietnam War, Tinker versus Des Moines, Iowa. And the court had to wrestle with whether or not a 13-year-old girl who wore a black armband to a middle school class had rights, had First Amendment rights to do that. What happened is she wore a black armband. An administrator walked up to her and said, "Take it off." She did not comply. They said, "We're going to suspend you." She did not comply. They suspended her, filed a federal lawsuit, went up to the United States Supreme Court, and that case decided the rights of students all the way up to today. And what the court said is, if you are not disrupting the academic environment, if you're not inciting violence or doing something that stops people from learning, then you absolutely have rights, even as a 13-year-old girl. Students do not shed their constitutional rights at the schoolhouse doors, is what the court said. And that remains true today. So what about Full Sail? What about you? Do you have any rights? The answer is really no, because you go to a private school, not a public school, and that's a critical difference. A public school is an arm of the government, and when the government tries to stop somebody from speaking or punish somebody for expressive conduct, then they run into the First Amendment, whereas a private school can make their own rules. They can theoretically censor your speech all they want, and your right is to rely on some agreement that you came to with the school, a student handbook, some policy that may have been broken, but you don't technically have a First Amendment right to be able to complain about what a private school does. And that has come up occasionally in these national anthem protest cases where student athletes will want to protest or kneel during the national anthem. And the public school students that want to do that likely have a First Amendment right to be able to engage in that type of expression, whereas a private school student would not, nor would a professional athlete who works for a private company, not the government. So the next question is, do students know their rights? And the polls and the statistics that have come out have pretty much shown that students today have a very unreasonably narrow view of their rights under the First Amendment. For example, only 39% of college students believe that hate speech is protected by the First Amendment, when in fact it is. Most even agree that they have the right to shut down offensive speech that's happening on college campuses or other campuses if they don't agree with the speaker. And a shocking number, about 20% think that they can use violence, that it's appropriate to use violence to shut down offensive speech. During the Q&A session at the end, and I hope there's some questions, I'd be interested to know, what some of your thoughts are on that. But we're seeing some very interesting statistics coming out of the college campuses as far as students' understanding of their rights and of their belief in the ability to shut down other people's rights with whom they do not believe. Another interesting statistic is that, and then this is the slide that shows how many people believe that they should be allowed to say something on campus, whether it offends somebody or not. And you can see a fairly small number of students think that they should be allowed to engage in offensive speech, whereas offensive speech is clearly protected by the First Amendment. And as this slide shows, the younger the students are, the less that they believe that they have the right to engage in offensive speech on campus. Now, adults don't do much better than students when it comes to knowing their rights. Only 39% of American adults can name a single right protected by the First Amendment. That's pretty shocking. And less than half identified freedom of speech as a First Amendment right. So, hopefully when you leave here today, you'll know more than half the country, and you probably do already. So let's get into the specifics. What does the First Amendment protect? As the slide here shows, obviously more than words. The First Amendment protects all kinds of categories of content. Now, obviously, it does protect words, books, and texts, and other writings. That was the primary focus of the First Amendment when the Founding Fathers drafted the Bill of Rights. The Bill of Rights itself is protected by the First Amendment as a writing. But are all words protected by the First Amendment? What about obscenity or profanity? Is that protected by the First Amendment? Cursing? Do you have a right to curse? Anybody think so? Yeah, it's probably not shocking to understand that, yes, the First Amendment protects the right to engage in profane language. There was a case involving a man who went to a courthouse wearing a jacket that said, "F the draft," United States versus Cohen, a famous case in the 1960s. And he was found in contempt, he was prosecuted. The court ultimately held that his wearing the jacket, using that profanity, even in a courtroom, was protected speech because it was intended to send an anti-war message. And therefore it could not be restricted. So you have the right to curse, the right to engage in profane language. Obscenity is different. That we're going to talk about involves sexually explicit speech that meets a very specific test. But profanity is very different from obscenity. What about the 7 dirty words that we hear about that you can't say on television? I can say them all very fast, but I'm not going to do it on this stage. You can come up later. But what about these 7 dirty words? Can you say them on television? Is that protected speech? If not, how do they get away with it? That comes about as a result of the regulation of broadcast television during primetime hours when children are supposedly able to watch or likely to be watching. And the courts have said that you have, as the government, the FCC has the right to restrict some amount of speech in the interest of protecting the virgin ears of children who might be watching and might be offended during those broadcasts. But that's been the subject of a lot of litigation over the years, the extent to which the FCC can actually regulate content on television. There was a Hill Street Blues episode that showed partial nudity that went up to the United States Supreme Court and resulted in quite a bit of debate over the continued ability of the FCC to regulate this kind of stuff, given the existence of cable television and Netflix and the internet and all these other forms of television communication, which all seem to be merged into one in our cable packages. How many people really recognize that there's a distinct difference between what is available and what can be shown on broadcast television stations versus cable stations. Well, the law is very different, but people don't seem to recognize that very often, and the courts are starting to wonder, why do we have these kind of artificial distinctions? But at least for now, the 7 dirty words and the regulation on broadcast television has been upheld. All right, what about banned books? We hear about efforts to ban books. How can you ban books under the First Amendment if they're protected under freedom of speech? Well, typically censors will try to engage in political pressure and try to force libraries to not take and accept certain books based on inappropriateness in schools or racist material and so forth. It's very difficult to ban a book in the United States. However, there have been some pretty successful efforts by parents to get certain books out of libraries, and particularly school libraries. And here on the slide is a list of some of the top 10 books that have been banned over the years, some classic novels, and we still see these fights happening now. We still see efforts to ban these types of novels based on political correctness, based on claims that the material contains racist or bigot content and information. But it's very difficult to do so consistent with the First Amendment. All right, let's talk about movies and graphic arts and pictures. Is that protected speech? Well, that should be pretty obvious that movies are protected by the First Amendment, but in the early days, it wasn't so clear. Before 1915, there were no restrictions on the content of movies, so it was basically anything goes. It was like the early days of the internet. Nobody really knew what to do with this new form of communication. There was all kinds of movies coming out, but then the censors started to say there's too much sex and violence in movies in the 1920s. Imagine what they would think now. But that resulted in the Supreme Court looking at movies and saying, movies aren't protected speech because they involve making a profit, which is an odd thing from a First Amendment perspective now. That's no longer the law, but that was the law back in the 20s, and that resulted in the censorship review boards basically deciding what movies could be released to the general public. And that kind of censorship would never be allowed today. There were attempts to try to use rating systems similar to what we have today to appease the censors and say, look, we're going to rate the movies, we're going to tell the public what's in them and who should see them, and that wasn't enough. There was a Catholic Legion of Decency that would basically decide what movies could come out in the 1930s. But finally, by 1952, the court said, movies are protected speech. It doesn't matter that they're making a profit. A newspaper makes a profit and it's still protected speech. So that is not a basis on which to deny First Amendment protection. So Hollywood breathed a sigh of relief, and since then they have operated under the belief and under the protection of this court decision that movies are protected speech. They have also adopted the MPAA rating system that allows for movies to be rated and allows the public to know what's in movies, and that is essentially staved off government regulation from Hollywood. The effort to label movies and rate them has kept the government at bay, and they've essentially concluded, well, that's enough for now. What about artwork? Well, yes, checkbox, that's obviously protected, but artwork has been the subject of controversy over the years. Some of it has tried to be banned, going back even to Michelangelo's days. This is The Last Judgment that sparked a lot of controversies in the 1500s with the attempt to try to cover up some of the nude bodies that were ascending to heaven or descending to hell. The Council of Trent didn't like that much, and they declared it to be obscene because of the nudity. And even after Michelangelo's death, they forced painters to paint over the naughty bits in the painting and make it then acceptable for the public to see. We wouldn't see that so much in the United States, but in the US there have been issues with artwork. Robert Mapplethorpe's exhibit, for example, is a classic example. This one was called The Perfect Moment, and it was a collection of 175 Mapplethorpe photographs that opened in Cincinnati, Ohio in 1990. It included things like classic nudes, flowers, a couple of portraits of nude children, and 5 explicit images of S&M culture in New York. So the museum became the target of intense political pressure. The censors were demanding that the museum take the exhibit down and that it be canceled, the tour be canceled and so forth. And ultimately the museum relented, took it down, but then opened it back up, and the museum was actually charged with obscenity, the first charge against a museum for obscenity laws, obscenity violations in the United States. A close friend of mine and an excellent First Amendment lawyer by the name of Louis Sirkin defended the museum and the Mapplethorpe exhibit and ultimately obtained an acquittal of all defendants on all charges. And that was the last time they tried that with the Mapplethorpe exhibit, but other artwork has caused controversy over the years. There was a case involving a nudist peace sign created on Valentine's Day in 2003 down in South Florida, where a bunch of people, naturists, wanted to get together and form a peace sign protesting war. The Department of Environmental Protection got wind of it and said, no, you have to wear bathing suits. It's a federal park, and there's an ordinance that says bathing suits are required. So they sued in federal court, and ultimately the court issued an injunction against the Department of Environmental Protection. Said, no, this is First Amendment protected. These people have a right to be in a state of nudity because they are sending an anti-war message. And that's typically what we see in these naturist, nudist cases. There have been efforts to try to convince the courts that being nude itself is a First Amendment right, that you have a right to nude sunbathing, for example. And those cases have not been terribly successful. The courts have essentially said, no, you're not trying to send any message by nude sunbathing. But you gather in a peace sign and you start demonstrating against the war, we're going to then recognize that this expression that has been created sends a message and you're entitled to First Amendment protection. I represented a topless protester in Daytona Beach who protests topless during Bike Week, and she organized about 10 years ago a march down Main Street Bridge to protest the nudity ordinance out there. And basically what was happening is all these kids would come in for spring break and Bike Week, and they would flash or they'd do something that violated the nudity ordinance, and they would end up with a criminal charge. The paddy wagons would stack up, they'd have twist ties ready, they'd arrest all these girls for violating the nudity ordinance, and they'd get a bunch of money, and all these kids would leave with a criminal charge and probation and a record. And so this organizer, this protester, her name is Liz Book, decided that's enough. She was an older woman, but saw that these kids were being harassed, and so she decided to protest the enforcement of the nudity ordinance. So she organized a big march across Main Street Bridge during Bike Week and took off her top, and immediately the police covered her up and took her to jail. So we defended her and challenged the ordinance and argued this was an effort to engage in political speech. This was a protest against the nudity ordinance. And the court agreed and dismissed the charges, and she prevailed. So next Bike Week, she went out again and protested again, arrested again, this time under a disorderly conduct statute. And we said, okay, how many times are we going to do this? We represented her again and argued that the First Amendment protects her actions, even if it was potentially considered disorderly under the disorderly conduct statute, because you can't apply a statute in a manner that violates somebody's First Amendment rights. And so we prevailed in that case and got an acquittal, and ultimately the city gave up. They were the subject of a lawsuit. We filed a lawsuit against them, and Ms. Book got paid, and as far as I know, she's still protesting today. So sometimes you win these cases, and sometimes you lose, but if there is a message associated with the nudity, that's an important aspect of showing First Amendment protection for live speech. What about tattoos? I bet you there's a few people with tattoos in here. Mm-hmm. Yeah. Yes, actually tattoos, for a long time, the courts did not recognize whether the fact that tattoos have an aspect of expressive speech, that they should be considered artwork on the body, that they have components of speech. But there was a case a couple years ago filed by a tattoo parlor in Key West called Southernmost Tattoo, and it was denied a license by the city of Key West because it wanted to open and right in the middle of everything in Key West, and the city didn't like tattoo parlors. And a lot of these First Amendment cases involving businesses come up in licensing and zoning disputes. So we see a city will pass a law that says you have to locate all tattoo parlors in the industrial zone or in the swamp or in the pig farms where there's no infrastructure and there's no ability to actually reasonably open and operate. And that's a zoning restriction, which is essentially a zone out because nobody would actually be able to open there. Or they'll impose rigorous licensing restrictions and investigations and thousands of dollars in application fees and so forth, all in an effort to try to dissuade people from opening disfavored businesses, whether it's tattoo parlors or fortune tellers or adult entertainment. It all kind of involves the same effort by government to shut down speech using licensing and zoning. And this was a case like that. The tattoo parlor was denied a license. They filed a lawsuit in federal court. And just in 2017, really for the first time, the courts recognized, the 11th Circuit Court of Appeal recognized that tattoos are protected speech. There's no reason to treat a picture on a human's body any different than a picture on a piece of paper. You would think that that would be a rational decision that would have been made a long time ago, but it was just last year that the ruling came down. Another victory for the First Amendment there, in that the city had to pay $425,000 to the tattoo parlor to settle the case after the court ruled, which is not a bad way to start a tattoo business. Live performances. This is another kind of given. Live performances are protected by the First Amendment, and this includes protests. We talked a little bit about that before. One of the really a famous protest case involved burning of draft cards during the Vietnam War, if you guys ever read about that one, the O'Brien case. But a lot of people were burning the draft cards during the Vietnam War in a show of anti-war stance. And there was a statute that said you had to always keep your draft card on you. And by burning the draft card, it was obvious that these people were violating a federal law, and people were prosecuted for it. But it became a very powerful anti-war message, burning the draft card. And so we saw that case go up to the United States Supreme Court, and unfortunately and surprisingly, the court said that's not a First Amendment violation, because the statute that was passed was designed to address another issue. It was designed to make sure that people were ready to be drafted into service and that they could produce proper identification. It was not directed at speech. No one was trying to censor anybody's speech by passing that statute. Now, that O'Brien case, which is the name of it, has been criticized by many legal scholars as wrongly decided. It was in the heat of the Vietnam War, but it is the law, and it sets forth the test for when expressive acts are afforded First Amendment protection. Plays are also protected speech. There's a famous case involving the play Hair, the old 1960s rock and roll play that involved full nudity at the end of the show on stage. And some communities tried to ban the performance of the play as not being consistent with society's interests, and very broad restrictions like that. And ultimately the Supreme Court said, no, you can't ban a live performance. That's a prior restraint on speech. That's not allowed under the First Amendment, and therefore the play can go on. Street performers, they have First Amendment rights. We've gotten involved in some of those cases in St. Augustine, where street performers want to go out and hustle for tips and show their talents, and they get into conflicts with the business owners who also want access to the streets to be able to have tables and chairs and conduct business in the streets, particularly the restaurants and cafes. So we've gotten some injunctions against the cities for violating First Amendment rights of street performers by trying to drive them out of the city. Nude dancing is protected by the First Amendment according to the United States Supreme Court, although the court said it's within the outer perimeter of First Amendment protection, which basically means we have to recognize First Amendment protection for nude dancing because there's no logical reason not to, but we don't like it. But they still do it because they have to. And essentially what the argument is that nude dancing is designed to send a message of eroticism from the dancer to the patron. And since we have that sending of a message, it's the same as any other message, which is going to afford the activity First Amendment protection. Fortune tellers, they're protected because why not? We've been involved in some cases with fortune tellers that has required us to assert First Amendment rights in order to get them opened as a business, because cities like pawn shops and like tattoo parlors and adult entertainment, some cities and counties don't want fortune tellers in their area, so they make it difficult for them to get licenses. But businesses that are engaged in First Amendment activity, like fortune tellers and newspapers and adult entertainment, have special rights. They can't be zoned out of existence. They can't be made to pay unreasonable licensing fees. You can't make it hard for them to open and operate under the First Amendment. So they have rights as well. And here's one, video games. Got any Twitchers in the audience, any video game fans? Video games are, at this point, protected speech, but it was a long road before the court would finally recognize the First Amendment rights of video games. And while it seems obvious that video games should have First Amendment protection, they're art and they have all kinds of literary features, the Supreme Court only ruled that they were protected by the First Amendment in 2011. That's a case that we were involved in and filed a brief in, Brown versus Entertainment Merchants Association. But before that, there were many state laws that would prohibit minors, for example, from buying mature-rated video games or video games that featured violence and so forth. There were requirements that these games have warning labels or be rated and so forth, that you must have a parent's permission in order to buy certain games. And all of these laws were challenged, and the courts were a little bit inconsistent about whether video games were protected speech. Some of the judges didn't really understand the strong literary, deep, rich content that's involved in most video games. Some of the older judges think about Pong, like that's not protected speech. And well, they've come a long way since then, Your Honor. And ultimately, the courts started to realize maybe they're onto something here. These video games involve plot lines and historic battles and love stories and everything that you typically see in art and literature. And ultimately, the Supreme Court in 2011 recognized that video games were protected and struck down all these laws that tried to restrict minors from buying protected video games and labeling laws and warning disclosures and so forth. Ultimately, the video game industry adopted the ESRB video game labeling system, and that's what's used now. And that's kind of the compromise that the industry has reached with the public and with concerned parents and so forth. These rating systems are designed to advise people what's in the games, what might be appropriate for minors and so forth, and you'll see the ratings down there. But there are still people who don't like it, and there are some that still believe that video games cause aggression in teens or are responsible for school shootings and so forth. And we're seeing a lot of these arguments come up again after the Parkland shooting. In fact, just last week, or no, a couple weeks ago, President Trump met with representatives of the video game industry in an effort to try to explore, again, whether or not violent video games cause real-world aggression. And to date, there has never been a single study that has shown that there is any correlation between playing violent video games and real-world aggression. But the Parents Television Council and others have a strong belief that we've got to do something, and that something is ban violent video games, apparently. So I don't know what's going to happen with this. President Trump said that this is going to be the first of many meetings with the video game industry, so this issue may reemerge somehow in some form in light of the school shootings. All right, what about websites? Are websites protected? This is an issue I like to talk about because most of my practice involves internet law. Website content is protected speech, and that should be fairly obvious because essentially what we're dealing with is other kinds of protected speech that is compressed into a website that is displayed on a computer screen, whether it's text or movies or graphic arts, logos, etc. It's all considered protected speech, and that was decided in the early days of the internet in a case involving the Communications Decency Act. It was an effort to try to make all online content decent. It was signed by President Clinton and quickly enjoined by the courts who realized that's a blatant violation of the First Amendment. From what I understand, most of the content online is indecent, but at this point, it's almost laughable to think that there would be a law saying that everything online has to be decent, but that was actually the law that was passed in 1998. It was declared unconstitutional by unanimous Supreme Court who found it to be a violation of the First Amendment. What about domain names? Are domain names speech? No, they're not speech. They're held to be more of an address, more like a phone number or a designation of a location as opposed to having any inherent speech quality. It's really just a location on the internet. Now, I can envision some domain name, some long domain name that might have some kind of expressive component to it, but so far domain names have not been afforded First Amendment protection. Here's an interesting one, search engine results. Google would really like to have their search engine results found to be protected by the First Amendment for lots of reasons, including antitrust laws, which prohibit the government from enforcing antitrust laws against content, speech, that's protected by the First Amendment. And the argument is that there is a unique effort that is used to arrange search results. Algorithms are used, but there's human effort that goes into deciding what goes where. It's kind of like being an editor of a newspaper, deciding what to put above the fold. And so, therefore, the arrangement of search results, what to include, what to exclude, how to arrange them, should be protected by the First Amendment. We don't have a decision on it yet. It's an open question, but it's a very important question for the website operators, the search engine operators, and it's one I expect will be resolved at some point in the near future. There is a special type of protection that is afforded to user-generated content, user-generated speech. And what do I mean by that? We're talking about YouTube, for example, or Twitter, a platform that allows third parties to post content, any social networking site, any blog site that accepts comments. The third-party speech is a potential source of concern, a potential source of liability if it's illegal. So if somebody posts, something illegal or a threat or something that invades somebody's privacy or that's defamatory, the platform operator like Facebook or Twitter or YouTube shouldn't be held responsible for the content of that third-party speech. And that is, in fact, the law. There's a statute, a federal statute called Section 230. It was part of the Communications Decency Act that I mentioned before that wasn't struck down by the courts. So they saved that part. And it basically says that a network operator, an interactive computer service, is not responsible for third-party speech. There have been some changes to that recently that we'll talk about in a little bit, but the general concept is that Congress recognized in order for these businesses to be able to survive and for new online innovation to occur, they can't be held responsible for every user that does something illegal or posts something unlawful or tortious on their platform. Otherwise, they'd have to look for every post, every piece of content that's posted on their platforms, terabytes of information on a daily basis, monitor it constantly to make sure that there's no illegal content. That wouldn't work. The internet would come to a screeching halt, and that's not the law under Section 230. But there's been some efforts to change that, as we've seen complaints about facilitating terrorism on Facebook or Twitter and sex trafficking and so forth. I mentioned there's efforts to restrict minors from accessing adult content. The first one was the CDA, as I mentioned. There was another attempt after the CDA. The U.S. government passed COPA, the Child Online Protection Act, and that was an effort to try to force all websites to use credit cards or some sort of age verification before an adult website could allow access to sexually explicit speech. And the court there found that that's unconstitutional. The credit card companies, by the way, didn't like that at all. They don't want their credit cards being used to verify age because they like when kids get credit cards. They want you to get hooked on using a credit card or a debit card early, so then you keep doing it when you're an adult. And they didn't want kids to be excluded from getting credit cards or for there to be this effort to try to show that only adults are using credit cards. So they pushed back on that, and the courts ultimately looked at this statute, the Child Online Protection Act, and said it's unconstitutional, and that's no longer being enforced. So essentially right now we have no law on the books that requires any kind of age verification for adult content on the internet. The states have tried it. Various states have tried to pass laws saying that you've got to use age verification if you're operating an adult website, but all of those have been struck down based on the First Amendment and on what's called the Commerce Clause. And the Commerce Clause is basically a law that says the internet is to be regulated at the federal level, not the state level. You can't have a bunch of inconsistent regulations of the internet because it's available nationwide and indeed worldwide. And it's the same concept as the width of railroad tracks going across state lines. You can't have different states saying that railroad tracks should be this big or this big or this big because the railroad's got to go all the way across without interruption. And so certain things that involve interstate commerce can only be regulated at the federal level. And the internet is one of those things. So the states failed in their efforts. There's some new efforts now to impose age verification. The UK just did it in the United Kingdom as of this coming fall, you're going to have to produce an ID and get a special code, a token, like a blockchain token or some other token, to prove that you've produced an ID before you can visit an adult website. Now, the UK doesn't have the First Amendment. They have similar concepts, but they don't have a strong First Amendment like we do in the United States, so they can get away with that. There are efforts to try to impose that same kind of thing in the United States, but based on these laws that we're talking about, it would be very difficult to do so. Advertisements. Is advertising protected speech? Some speech that proposes a commercial transaction. The courts have said, yes, you do get constitutional protection, but the test is going to be a little bit different. The government's going to have a little more leeway in regulating advertising. And it uses something called the Central Hudson test, which first of all requires that the advertisement be truthful, not misleading, and involve a legal product. As we'll see, there is a certain amount of deception and lying that's protected by the First Amendment. But when it comes to advertising, the product must be legal and the advertising must be truthful. Otherwise, it's false advertising. Also, the government must show some kind of real interest in regulating the advertising. They can't just regulate certain kinds of advertisements because they don't like them or they don't like the product. They have to show that there's some legitimate government interest and that there is a good fit between what they're doing and the interest that they're trying to achieve. So essentially, the answer is yes, you get protection if you're advertising, engaging in commercial speech, but the government has a little more leeway in trying to regulate you. And this comes up in these tobacco ad cases, where you see on tobacco products we have a mandatory Surgeon General warning, which requires certain disclosures about the health risks of tobacco and tobacco use. Now, the government tried to go further than that and passed a law saying that all tobacco advertising and products have to have graphic depictions of lung cancer and other health hazards that will be caused by use of tobacco. And the tobacco industry fought that on First Amendment grounds and said, if you do that, if you make us do that, you're essentially forcing us to adopt that position. It's forced speech, and forced speech is unlawful under the First Amendment. You can't make a company or a person say something that they don't believe or take a position that they don't agree with. And they won. The tobacco companies won on that issue, and the regulation was enjoined, and that's why you don't see some of these graphic images on tobacco advertising or products. In other countries, you will see that, but not in the United States. And that's really where we're at now. The government so far hasn't pushed it any further after that was held unconstitutional. Sometimes we see issues with gambling advertisements. And again, the First Amendment seems to always come in when there's some disfavored product or service, sex, drugs, rock and roll, gambling. Here we have issues with gambling advertisements. And the problem with gambling is that it's such a bizarre restriction in the United States because we have laws, federal laws, that prohibit things like sports betting and broadcasting of gambling advertisements and other online gambling. But virtually every state has some form of legal gambling. And the courts have looked at this and said, what is the policy regarding gambling? You're saying that gambling causes all these evils and therefore it can be restricted and gambling advertisements can be restricted, but you have an incoherent federal policy when it comes to regulating gambling because you allow all these different kinds of gambling, and it seems like you only want to allow the gambling that you like for the people that you like and the places that you like, but you're not proving to the court that gambling itself is illegal, as they would have to do to justify some of these restrictions on advertisements. So there's a U.S. Supreme Court case, New Orleans Broadcasting Association, that essentially said that the broadcast ban on gambling advertisements is unconstitutional. And what happened there is there was a state that offered a lottery that wanted to advertise on TV, and that's illegal under the gambling advertising ban because the broadcast advertisement could be received in states where the lottery was illegal. You can't really control broadcast given the nature of broadcasting. It goes across state lines. And so that resulted in the advertisement being illegal. It was challenged, and the court said, your policy regarding gambling is so incoherent that we can't find that there's a substantial government interest in you doing this and you restricting these gambling ads. And also, by the way, the manner in which you did it was too broad, and so we're going to strike it down. So we see issues with gambling come up quite often in the First Amendment space. Third-party advertisements. I mentioned third-party speech, people posting things on Facebook and YouTube and so forth. Well, people like to post advertisements on those platforms as well. Think about Craigslist, Backpage, which is a company that's in the news quite a bit regarding third-party advertisements. And the issue is, what happens if an advertiser posts an ad that's illegal, such as for prostitution or sale of drugs or what have you? We had Silk Road a while back that had all kinds of illegal advertisements on it. And the question is the platform operator, the network operator like Craigslist or Backpage, are they liable for the content of ads posted by third parties? And this has been a hot button issue over the last few years, particularly in the area of sex trafficking, as a number of anti-trafficking advocates have tried to shut down sites like Craigslist and Backpage and try to blame them for the content of advertising by third parties. And yet they have this Section 230 that I mentioned that says they're not responsible for any content posted by third-party advertisers. And so the anti-trafficking advocates didn't like that, and they have now pushed through a law called SESTA that just passed last week that says you no longer get Section 230 protection for sex trafficking. So they've stripped out this one narrow category of speech, of content from Section 230 protection. So now, all of a sudden, Twitter, Facebook, all the big companies are going to have to step back and make sure that none of their content on their site constitutes any form of sex trafficking. And the Congress went one step further and said, oh, in addition, there's going to be a broad federal prohibition on promotion of prostitution or facilitation of prostitution, not trafficking, prostitution on the internet. So not only do they have to make sure that they don't have sex trafficking ads or content on their site, they have to make sure that they don't have anything related to prostitution. So we're going to see a lot of new rules, and we're already seeing a lot of new rules being imposed by these platforms, including Microsoft with Skype and Facebook and Twitter. We've seen about 10 websites shut down already, or shut down categories. Reddit has shut down categories related to escorts and others. And so the law, even though it's not been signed into law yet by President Trump, its passage is already having a pretty significant impact on online speech in the last few days. All right, let me talk about computer code for a second. This is it's an interesting one, and it's a difficult one. Computer code has speech-like qualities, but in the end, it's just a lot of ones and zeros. It's the type of instructions that most humans can't understand unless you're a programmer. So the question for the courts is the underlying computer code protected by the First Amendment? And this becomes very important in a number of cases where the government tries to restrict the sale of computer code or the distribution of code. Excuse me one sec. One of the first cases involving computer code and its protection as speech dealt with encryption. And in the early days of the internet, people were struggling for ways to encrypt their content so that the government couldn't snoop and other people couldn't access their private emails and so forth. Little did they know what would happen in present day. But in those days, they were looking for ways to use encryption. The government didn't like that, surprisingly enough, and the government treated computer code that provided encryption capabilities as munitions, like guns and bombs, that can be regulated by the Department of Justice. And the government tried to stop the circulation of this computer code by a guy named Mr. Bernstein. And ultimately, the Electronic Freedom Frontier, the EFF, took the case and fought it, and it was the first case that recognized that computer code could be protected by the First Amendment. And the court did actually decide that, and also decided that that encryption code is particularly important because it protects not only freedom of speech, but privacy interests of the people who are using it. So it has unique protection and unique utility in the marketplace of ideas. So there is some support for the idea that computer code is protected speech, going back to 1999. But no one knows how much code is protected. Are all types of computer code protected? There's a debate between source code and object code. If you can read it, if anybody can read it, maybe it's protected. If only a computer can read it, maybe it's not. But it's a debate that's going on and is not settled. The courts are kind of all over the map on it. But there was an interesting case that dealt with the Apple iPhone unlock case, where the San Bernardino shooter left behind an iPhone after he died. And the government, the FBI, was very interested in getting access to that iPhone to make sure that nobody else was involved and to try to see who he contacted and so forth. And as those of you that have iPhones know, once you put in your code 10 times, you don't get access to the phone. It can't be unlocked. And that's what the FBI did. They kept trying to guess his password. And they guessed 10 times and they got locked out. And so they said, Apple, can you help us out here? And Apple said, well, we really can't do that because we don't have a backdoor once you do that. And if we created something like that, it would risk everybody's security. And that's not something we want to do to our users. And not only that, from a First Amendment perspective, you are forcing us to create speech, because this computer code that you want us to create for you to unlock the phone doesn't exist, and we have to create it. We have to draft it. And surprisingly, the court initially ordered Apple to do it. And it was a quick hearing without Apple's participation and so forth, and it was in the heat of the moment. Apple pushed back and said, no, you can't force us to do this. It's a backdoor that we're not inclined to create, and it's going to risk everybody's security. Before the court heard arguments on the case, apparently the FBI got some Israeli tech firm to unlock the phone. And we don't know all the details, and they don't admit to much, but somehow they got access to the phone, so it mooted the issue. So we don't know next time this comes up whether or not Apple is going to be required to do something like this, but that's one of the reasons why it's important to know whether computer code is protected speech, because it affects arguments like this, i.e. whether or not Apple can be forced to create speech that it doesn't otherwise have. All right, before we leave computer code, there's an interesting issue about code and speech, and that is if computer code is speech, are viruses protected speech? That's the kind of murky waters you get into when you start affording First Amendment protection. And it's going to be difficult for the courts to try to decipher whether viruses should somehow be accepted from the protection of speech if computer code is otherwise accepted as protected by the First Amendment. There's a couple ways to do this. One is you recognize that all of it's protected, including viruses, but that there's a compelling governmental interest in restricting viruses as a type of speech that we're going to allow. And you can do that, you can make that argument, but it's only accepted in very rare cases. Typically the courts do not allow censorship of speech based on content. And so that's essentially what you're asking here. You're saying this type of content we want censored because it does bad things. It's a difficult argument to make, but it's possible in this case because of the damage that viruses can do to computers and to society in general. The other way to do it is to carve out viruses as unprotected speech, or say that it's not protected. They're going to have to come up with a way to do that. They're going to have to try to identify what's different about a virus code that makes it not speech as compared to everything else that looks a lot like it but just does different things. So it's one of those things where it's an unintended consequence of giving First Amendment protection to a type of speech that we might like, because there's always abuses. And there was an interesting computer code case that came up with 3D guns. You have these CAD files that can allow a printer. These printers are so good now they can print an untraceable 3D gun that shoots and fires. And that obviously gave the DOJ some concern. And so they immediately categorized these CAD files as munitions again, like the encryption software, and regulated it and said you can't use it. Well, there was a group called Defense Distributed that posted these CAD files to a news group or somewhere and showed people how to download the 3D CAD files for the Liberator gun, and it was downloaded 10,000 times in 2 days immediately. So the government jumped in and sought an injunction, and actually this time the code was upheld as munitions, and otherwise the court deprived it of First Amendment protection and said it's not speech. But you get into some pretty fine distinctions here when you say that encryption code is speech, but CAD files are not, and they had to really struggle with it. They didn't attack the issue of whether it's speech head on. They just basically said, well, the interest in public safety is so great here that in looking at whether we should enjoin the distribution of these files, the public safety interest outweighs any First Amendment interest that you might have. So without coming right out and saying this is protected or not, it just relied heavily on this concept of public safety and found that the CAD files were munitions. We get into issues of things like artificial intelligence. Is AI protected speech? Now, the information is not created by humans, but is that necessary? Do you have to have a human involved in creating speech in order for it to be protected? And I can think of examples such as with music and computers generating music, where a human doesn't necessarily create all parts of it, but they show a synthesizer or something, or a computer, what to do to produce certain sounds. And the end result is protected speech. So maybe AI should be the same thing, but the question becomes how much human interaction do you have to have with the resulting speech in order for it to be protected? And if you just simply program something to create its own speech and you're not involved in the generation of the content, does that end result constitute protected speech? It wasn't spoken by any human being, but humans did program the computers to do it. And there's also a very difficult question of who owns the speech. If it's created by a robot, can a robot own the speech for copyright purposes and so forth? It's beyond the First Amendment issues, but it's some very thorny issues. I can tell you that the legal status of AI is unsettled. It's bound up in this whole debate over computer code, but there is, at least in the academic circles, there is an effort to try to get AI protected under the First Amendment based on its impact on the audience, on its impact on the viewer. So if speech has some sort of value and can be understood by the viewing audience, then it should be protected by the First Amendment, regardless of who happened to have created it or what involvement that robots might have had in creating the speech. All right, here's one just real quick, filming the police. This was an issue that has been up and down the courts for a while. Ultimately, the courts have largely concluded that you have a First Amendment right to film the police as long as you don't interfere with their law enforcement functions. There is not a Supreme Court ruling on this yet, but we expect that it could come up to the Supreme Court because there have been some inconsistent rulings by the lower courts as to whether or not you have an absolute right and under what circumstances, but the vast majority of the cases say, yes, filming the police is protected by the First Amendment. Now, how about animal cruelty depictions? This is an odd one that I mentioned earlier about the bullfighting video. Now, animal cruelty is a crime in every state. Okay, that goes without saying. But is possession of a video that depicts animal cruelty protected? Do you have a right to have that video in your possession? Well, Congress found that there was a problem with so-called crush videos. And you got to be careful what you ask in the First Amendment realm, but in connection with crush videos, apparently Congress was worried about videos that involved primarily women in high heels crushing things like spiders and roaches and little invertebrates. And there was enough of an interest in Congress to actually pass a federal law to prohibit this kind of content. There was no indication that there was a lot of it anywhere, but apparently it disturbed enough of the legislators to pass a federal law. But oftentimes Congress goes overboard when they pass a law, and they pass a broad prohibition on any video that involves any illegal act in connection with an animal. So that concerned people because it could affect things like filming a bullfight in Mexico where it's completely legal, but it's illegal under U.S. law, or even hunting out of season. And that was a case where we filed a brief in the U.S. Supreme Court and argued on behalf of the First Amendment that you can't create a new category of unprotected speech just because you don't like the speech at issue. There's these historically protected categories of speech, and there's some exceptions, but you can't create a new one. There's no basis on which to create a new category of unprotected speech. And the Supreme Court agreed. At the time, Justice Scalia was on the court, and he's deceased now, but he was a big hunter. And he was worried about the effect of hunting without a permit, and all of a sudden people are going to be going to jail because they took a video of an illegal act of hunting, theoretically violence to animals that involved an illegal activity. The law was so broad, they said, no, you can't do that. We're not going to create any new categories of unprotected speech. And that's a good thing for the First Amendment generally, because you see routinely Congress, the states, private parties trying to argue that the government should recognize some unprotected category. They should strip a certain type of speech that they don't like from First Amendment protection. But the law was declared unconstitutional in 2010. Lies, and more lies. Actually, protected speech under most circumstances, as I mentioned, not in advertising, can't lie in an ad, but you can lie to your friend, you can lie on TV, you can lie as a politician, and it's protected by the First Amendment under what's called the stolen valor case. It was a case where a guy said that he had military medals and he didn't really have them. And there's a federal law, believe it or not, that says you can't lie about having military medals. It was challenged in the courts, and the courts said, sorry, this is not a category of speech that we're going to strip from constitutional protection. There are some exceptions here, though. Defamation. You can't lie about somebody else that causes them damages. So we'll talk a little bit about that. Commercial speech, as I mentioned, misleading advertisements. But lying generally is protected speech. All right, what about some exceptions? First Amendment says Congress shall make no law respecting freedom of speech. Well, they haven't made any laws that have survived, but they certainly have recognized some unprotected categories. All right. Any new unprotected category of speech has to be very, very narrowly drawn, and it's unlikely to be accepted by the United States Supreme Court this time. But there's some categories that we've all just kind of know don't get First Amendment protection. The last one was recognized in 1981, being child pornography, but since then we haven't seen any new efforts that have been successful. Obscenity is one of the areas of unprotected speech. Now, obscenity is, I know it when I see it, right? The famous line, that's absolutely not the standard. The standard for obscene materials, and we're talking here about sexually explicit materials, is whether or not it fits the Miller test, and whether or not it involves sexual conduct, whether it's patently offensive, whether it appeals to the prurient interest in sex, or lacks literary, artistic, political, or scientific value. It's a mouthful. It's a complicated test. It's difficult to apply for both prosecutors and defendants. We've been involved in numerous obscenity cases, and they're terribly complex because they're focused on things like local community standards. What is the community standard for this type of material? Does the community accept it or tolerate it, or is it typically rejected in the community? Well, how do you even know what the community is these days? Is there a sense of what's acceptable in connection with adult entertainment in Seminole County or in Central Florida or Florida as a whole? And that's one of the problems with these obscenity cases is nobody really knows what the county is. Every judge rules differently. Some judges say it's the county, the community. Some judges say it's a county. Some say it's a tri-county area. Some will say it's the entire state. And some will say it's the nation as a whole. So you don't even know what community you're dealing with, let alone how to determine what their community standards are. And then you've got this issue of whether it appeals to the prurient interest in sex. I mean, how many people even know what the word prurient means? And we test juries sometimes, and we ask them that question. We've done polls to try to identify, does anybody really know that word? Do you commonly use it in a sentence? Yet you're using it in an obscenity trial to determine whether somebody goes to prison or not for otherwise protected speech. You're separating protected from unprotected speech based on whether or not it's prurient. And what we found is that most people have never heard the word, can't define it, and can't properly use it in a sentence. The judges still allow it, and the Miller test has survived many challenges. There's also a requirement that you take the work as a whole when evaluating it, which is very difficult with websites in particular, because if they claim that some video on a website is obscene, do you then have to look at the entire website? And if it's something like a tube site that has hundreds of thousands of videos, do you look at every video to determine whether or not the website as a whole is obscene? Do you look at all links? Do you look at one page? It's a very unworkable concept. It's still the test, and it's still used to determine what's legal versus what's not. But what I can tell you is that even with obscene material, you have a right to view it in your own home. You have a right to read it, right to watch it. You can't buy it. You can't transport it. You can't distribute it. You can't sell it. So I don't know how you get it there, but I guess you can make it yourself. I don't know. But once you get it there, it's okay to watch it under the Supreme Court's case in Georgia. Child pornography, pretty clear, not protected by the First Amendment. It's one of the historically unprotected categories of speech, but its status was actually not recognized until 1982 when the court rendered a ruling on it. Promoting or pandering underage content, even if it involves all adults, if you sell it as child pornography, if you claim, hey, this all involves 16-year-old girls, even if everybody's over 18, that's still illegal. It's pandering or promoting. Virtual underage content that uses young-looking adults or people that are made up to look young or surrounded by things that are indicia of youth, that is not illegal. That's protected by the First Amendment under the FSC versus Ashcroft case, and in that case, they recognize the rights of young adults to be able to participate in adult material. Illegal child pornography can actually include people that are fully clothed, minors that are fully clothed. And under the test to determine whether something is child pornographic, if it depicts the genitals or pubic area of an individual in a lewd or lascivious manner, then it's child pornographic. We've actually seen cases where people have been prosecuted for going to water parks and filming minors and focusing on genitals or pubic area, even in bathing suits. And that has been declared to be within the realm of the child pornography statute. There's also issues with morphed images where you have the head of an adult in the body of a child or vice versa, and the law with regard to that is a little unclear, but there is a federal prohibition on that. Then finally, as I mentioned earlier, there's this issue with teen sexting and self-producing content. You see a lot of kids now that are taking pictures of themselves in racy positions and sending them to each other. And technically, that's all child pornography. That's all prohibited by child pornography laws. And people have ended up getting prosecuted for sending these pictures to each other. And kids end up on the sex offender registry for 20, 30 years. I've had a few of those cases, and we've taken them in an effort to draw the public's attention to this being a problem. You can't use these laws that were designed for adults, that were designed to be used in a very different circumstance, and apply them to today's technology where all kids have a recording device that can very easily capture every moment of their private lives. And so it's an issue where the law hasn't caught up to the technology. But what has happened is that many states, including Florida, have passed teen sexting laws, which essentially give prosecutors an alternative to charge kids that are involved in this activity. And we pushed for that in many states and ultimately got the state of Florida to pass a teen sexting law. Now, if you're engaged in this activity, it's a $75 fine and some community service instead of jail for decades and the rest of your life on the sex offender registry, which is probably a good thing. The other exception that we want to talk about real quick is incitement to violence. You can't incite people to lawless action. It's not the same as hate speech. You have to actually try to get people to commit violence right away. So it's basically like inciting a riot. Say, let's go burn down a house. And that crosses the line. But you can discuss violence. So you can say, I think it's appropriate to burn down houses generally. Or I think that we should, overthrow the government. As long as you're not advocating that we go now and do it, that's where the line is in terms of the First Amendment. True threats are also not protected by the First Amendment. Different from a general threat that's directed at broad categories of people. It has to be a specific person or specific individuals. It's different than a conditional threat, such as, well, if you weren't so ugly, I'd kill you. That's a conditional threat. It's not something that is going to be deemed a true threat because there's a condition there that shows you I'm not going to really do it. But if it's something like, well, if it wasn't daytime, I'd kill you. Well, that could be a true threat because nighttime's going to come pretty soon. So there's some nuances there in determining what true threats are. Social media postings, we see the courts grapple with this issue of, is a posting on general social media on a Facebook page a threat? Is it directed at a specific person? Is it enough to strip that of constitutional protection? And so far, as long as it's not directed at a specific person, it will be deemed protected. We see a lot of these issues with threats in school as well, and to the extent that a student is engaging in disruptive behavior, schools have the right to expel that person or at least give them a hearing. Defamation, I'm going to go through this kind of quickly because I want to get some questions from you guys. Defamation is false statements of fact about another individual that causes a damage to a person's reputation. There's a number of defenses to defamation, like truth and litigation privilege and hyperbole, substantial truth. But basically, you can't lie about somebody and say something untrue about somebody that causes them damage. You can express an opinion. You can say that, I think this person stinks, or, I don't like the way that they carry themselves. But you can't say that they have a communicable disease, or they filed bankruptcy, or something that is provably untrue. Verbal acts, and this is essentially criminal conduct. Shouting fire in a crowded theater is the typical example, but other things can come up like assault or sexual harassment, solicitation of murder. It involves speech, but it is a criminal act in and of itself. It's been criminalized, and the real effort in engaging in the speech is to commit a criminal act and not to further a message. National security is accepted, so to the extent that the government wants to protect its secrets, like in troop movements or in other national security issues, it can assert an exception to the First Amendment. This is, of course, subject to abuse. We saw an important case of the United States Supreme Court, the Pentagon Papers case, which involved classified information about our movements in Vietnam and our activities in Vietnam. And the court said basically, once you have the classified information, you have a First Amendment right to publish it. But you are not allowed to force the government to turn it over. There's issues with social media that we've kind of touched on. There are some threats to the First Amendment, like a lack of understanding or knowledge, as we've talked about earlier. The willingness to surrender valuable First Amendment rights. Some people are willing to surrender rights if it gives them more safety and security. We have issues with the surveillance state, the NSA, knowing everything we say and do in terms of our emails and our website activity. That's a chilling effect that scares people into not saying things and not writing jokes and not making movies and not expressing themselves, knowing that somebody might be watching. But I do want to save some time for questions. This is a slide just for some groups that you might consider getting involved with if you're interested in anything that I talked about today. FIRE is a great group for student rights. The EFF is focused on digital freedom, security, and privacy. And then CDT is an Internet Freedom Organization based in DC. That's an excellent group to get involved with. Thank you for your time and attention. I look forward to some questions if you have any.
Thank you for joining us today. I have two questions from some viewers online. Both of them are actually instructors here at Full Sail within our media design master's degree program. The first question I would like to ask is from Bartley. To what extent does intent to harm or defraud come into play when determining the First Amendment protection?
Right. So it would depend on what the underlying speech is. So if you are engaging in fraudulent conduct, that is already a crime. However, the government has to prove that you intended to engage in the fraudulent conduct. It's a criminal law issue, and it requires a showing of criminal intent. But if your speech involves, let's say, a lie, and you simply intend to not tell somebody the truth, that's going to be protected by the First Amendment. So there's a fine line between fraudulent conduct and just simply lying. But if you're essentially trying to get somebody to act on your speech and give you money, let's say, or turn over property or do something in reliance on your speech, that can be fraud.
Okay, great. And we have one last question from Colleen. This one's a little bit different. Okay, so her question is, how does this apply to students submitting work that is not intended to be made public? For example, if the student has a right to be offensive to an instructor for their platform or in class, which is not considered to be public.
Okay, so you certainly have a right to express yourself in private, and so if nobody ever hears the offensive speech, then there's not going to be a First Amendment issue, probably. But if you publish your speech to a third party, then you have issues with potential defamation if you're saying something that's not true, and publication is a required element of defamation. So that basically means that you have to say something to somebody else about a third party in order for defamation to occur. And so, to the extent that somebody's having a private conversation that's not likely to result in any offense or any school discipline, but to the extent it's made public or overheard by a third party, then it can result in defamation or other school discipline. Any other questions? Looks like somebody back there.
Hi. I'm an instructor here, and I'm also a lawyer. So we oftentimes talk about this in class. But could you please make the distinction for students between your First Amendment right and what you're allowed to say and be entitled to keep your job?
Oh, yeah, great question. So that largely depends on whether or not you are working for a public or private employer. If you're working for a private employer, you have essentially no First Amendment rights. Your contract with your employer is, in most states, terminable at will, so they can terminate you for any reason or no reason whatsoever, including based on what you say. So you don't have a First Amendment right there. If you work for the government, including a government school, public school, or other government agency, then you have a First Amendment right. But the government also has a right to an orderly workplace and to be able to carry out their job. So there's a specific test. It's a balancing test called the Pickering test that is used to determine whether or not somebody's speech goes over the line. And if you are interfering with the workplace and the employer can't get their job done, or it's causing harm in some way to the employer, then you may not even have the ability to say that in connection with a public employer. Anybody else have any questions? Yeah, we have one over there.
Hi, my name is Benita.
Hi, Benita.
Hi. So everything that's going on with the gun laws, and these kids are very active in their speaking, and I'm very proud of them. But do you think what's going on with the gun laws and these group of students who are on CNN, do you think that this is somehow going to affect future laws and future student rights?
Well, you really have a mixture of constitutional issues there, don't you? You have Second Amendment rights, the right to bear arms, and you have First Amendment rights of the students. And what I do think that the result of the current debate is going to be is that more students are going to be emboldened to speak out. I think that the Parkland kids that are on TV and that have shown the courage to be able to stand up for their position will inspire lots of people to do the same. And that's the best thing for the First Amendment. A healthy, robust debate, as many points of view as possible that go into the marketplace of ideas, and you hopefully arrive at the truth after that debate. So I think that will be the end result. We'll see more and more student debates and more students participating in the process. What will happen with the gun laws is anybody's guess. That involves a lot of politics and involves the Second Amendment, which protects the right to bear arms. I think we had a question over here. I'll wait for the microphone.
Hi, my name is Rachel, and if I'm correct, you said that viewing obscene material in your own home is legal. So how can you get arrested for viewing that obscene material in your own home? How do people get arrested for that if it's legal?
Well, you shouldn't be arrested for it because it's not a crime. People get arrested for child pornography in their home. That's the typical one because receipt of child pornography and possession of child pornography is a crime. But if somebody's being prosecuted for merely viewing or possessing obscenity in their own home, it's not a crime under Stanley versus Georgia. You have an overriding privacy right under the First Amendment, one of the other rights that the First Amendment protects, to view even obscene material in your home. So that should not occur. If you are arrested, then you would have an absolute defense. Do we have any other questions in the audience before we wrap up? Well, I really appreciate your time and attention. Hopefully you'll use this information in your careers and know where the lines are in connection with protected speech. Enjoy the rest of your day, and thanks again for coming.